Let's dive into the legal and ethical framework that underpins every single real estate transaction.
Your entire career and your license hinges on getting the answer to this one foundational question right.
And that question is simply, is this person my client or just a customer?
This table is basically your cheat sheet. Your legal duties for each are completely different. Let's break it down.
When someone is your client, you owe them the highest standard of care, which we remember with cold AC.
First up is C, for care. This means being competent and diligent, but there's a really common exam trap here.
Your duty of care also means knowing your limits. Advise clients to seek out experts for things you can't do.
Next is O, for obedience. You work for your client, but pay close attention to that key word, lawful.
If your client gives you an unlawful instruction, like a fair housing violation, you have to refuse.
L stands for loyalty. This is a big one. It's their interests first, not your paycheck. Always.
Your recommendations have to be based on what's best for them, not on what gets you a bigger commission.
D is for disclosure. You're their eyes and ears. You must tell your client everything you learn. So if a buyer who's your customer reveals their top price, you must share that with your seller client.
A is for accounting. This is simple. Never, ever mix your client's money with your own personal funds. And the final C is confidentiality. What they tell you stays with you, and this duty lasts forever.
Okay, so what about customers? You're not their fiduciary, but you still owe them these three critical duties. Disclosing material facts is the most tested duty. A material fact could change a buyer's mind about a property.
This is huge for hidden defects. An obvious broken window is one thing. A hidden crack, you have to disclose it.
So what happens when your duties clash? The law is very clear. You cannot help your client commit fraud.
To avoid this kind of confusion, you have to disclose who you work for, but the timing is everything.
You must disclose at the first substantive contact. That's the moment casual questions turn into serious information. Here's a classic exam trap. A buyer gives you their max budget. You stop them and disclose you represent the seller.
And remember, it's not just professional ethics. Major federal laws give these duties some very real teeth.
See, it all comes back to that one question. Your answer determines which path you must follow.
Knowing the rules is one thing, but what will you do when a client asks you to bend them?